Good evening. Since my name ends with a D, I will be talking about voir dire and its significance in a criminal trial. Start off, voir dire comes from Old French, where voir means true and dire means to say. Putting that together, it basically means to tell the truth. In the world of criminal law, voir dire is the process through which potential jurors from the venire or panel are questioned to determine their suitability for jury service. It is also used to determine whether witnesses have the proper competency to testify or to decide on the admissibility of evidence. The process is usually conducted by a judge and the associated attorneys. The purpose of voir dire is to determine whether potential jurors will be fair, to reduce the chance of any biases, prejudices, or any individuals who may have experiences that could be sympathetic or harmful to the case. Do any of these individuals have associations or relations with any of the members in the case? The important questions are, can the juror be fair? Can they hear fairness? And can they see fairness? From the perspective of the attorneys, they must also determine if a juror is going to be someone who might be fair to you or onto the other side. The questions asked of potential jurors are generally open-ended questions and can start off with a simple, tell us about yourself. What do you do? From there, you can narrow the scope down to questions that might associate more with the case at hand. For example, if a case involves a wrongful arrest and a potential juror states their dad was a police officer, or maybe that they had poor experiences with police in the past, it could indicate a sympathy factor or a bias factor that might be ill-suited for a juror in this particular case. Attorneys can put together focus groups beforehand to establish what questions might yield the best results. Psychologists and associates can also be utilized and might even be present during the voir dire. An attorney may question a juror's suitability and have them removed through challenges. A challenge for cause indicates a legal basis for disqualification, such as bias, failure to understand experiences, etc. The other type of challenge is called a peremptory challenge and can be given without reason. The number of challenges for cause is unlimited, but the number for peremptory challenges is limited by statute, usually 6 to 10. A popular tactic by attorneys is trying to get the other attorney to waste one of their peremptory challenges on a juror instead of using one of theirs. In my opinion, I think the process of voir dire has the potential to serve its purpose, but there's always the potential for unsuitable jurors to slip through, or maybe one attorney has better questioning skills than the other, which leads to a lopsided panel. As to improvements that can be made to help the process, currently jurors are pulled from voting lists, but maybe when picking those names, they shuffle the zip codes a little, spread out where the jurors are pulled from to prevent too many individuals from the same community being involved. Increased diversity amongst the jurors is also recommended, and when I say diversity, I mean across the board. Race, social status, religion, culture, sex, age, etc. Pre-approved written questionnaires done before the voir dire to identify early potential issues would also be useful. Is a defendant entitled to a fair or perfect jury? I believe they are entitled to a fair jury, but I just don't really think it's possible to ever have a perfect jury. As stated before, there are just too many factors that can interfere to ever ensure things go truly perfect. But fairness, yes, this is something everyone should be entitled to and we should strive to achieve. Thank you.